Hello everyone, welcome to TUF, the UPSC factory. I'm your host for today, Tanmay Kale, IRS 2022 batch. So today we are again going to discuss the Indian Express newspaper for today, that is 10th of August 2024. Today there are not many, or I would say very few articles which are important for our exam. Okay, so let us continue with today's newspaper. What I've done is I have added the clippings of newspaper, clippings of the important article in this slide. So we'll discuss that only, we'll not discuss the whole newspaper today. Right. So first there's a article about the Supreme Court's verdict in the Manish Sisodia case, who has been recently released on bail by Supreme Court. So we'll see what is given in this article, right? So like there are many political things in this article which are not relevant for us, which are not important for us, regarding the functioning of CBI and ED. What are the comments of Supreme Court on that? So that is not important for us. What is important for us is the 3 points, the 3 reasons which Supreme Court gave while giving this judgment. The 3 points, these 3 points are important for us in our paper of GS2, criminal justice system, okay, and the polity also, because it relates to the fundamental rights of a citizen, right? Okay, so let us see what are these 3 reasons which Supreme Court has given before giving bail to Mr. Manish Sisodia. The first is that the court has said the principle of giving bail is a norm and giving jail to someone is an exception. Okay, it is an age-old principle which must be followed by all the courts in the country. So Supreme Court has reminded all the courts of that. Second is that speedy trial must be respected. Keeping that in mind, the accused behind the bars for an unlimited period of time while waiting the trial, right, violates his or her right to freedom, right to life under Article 21. Okay, because if they are behind the bar on trial, they are not able to exercise their right to life. Okay, there are many rights enshrined under the right to life. They are not able to exercise those when they are behind the bar, right? And thirdly, the main contention which Supreme Court has given while giving this bail to Mr. Manish Sisodia is that the right to bail in the cases of delay coupled with incarceration of for a long period, मतलब जेल में बहुत ज़्यादा टाइम तक रखने हैं, read into bail provisions of the Code of Criminal Procedure and प्रिवेंशन ऑफ मनी लॉन्ड्रिंग, मतलब ये इन दोनों प्रोविज़न में होना चाहिए, राइट? ये दोनों प्रोविज़न में है, होना नहीं चाहिए, दोनों प्रोविजंस में है. सो पर्सन शुड बी गिवन बेल, राइट, इवन when there is a long period of jail which has been done, right? So these 3 principles Supreme Court has given while giving bail to Manish Sisodia. Okay, this is the only thing which we can take away from this article, right? So now we'll move forward to the another article, which may be the last article, but a very important and very good article which came in today's newspaper, that is regarding the sub-quota, the issue of sub-quota of in the community of SC and ST. So let us see what is given in this article here, right? So as you all know that recently Supreme Court under a 7 bench has given a judgment regarding the sub-classification of SC community, yeah, right? It was a case from the state of Punjab which went to Supreme Court, and Supreme Court has given this verdict that there should be sub-classification of SC on the basis of the creamy layer concept, right? So this article dwells into that judgment only, and what it aims to deliver is that to understand that the Supreme Court judgment was not actually about diluting the reservation policy which is there for the SC and ST community, right? It was not for diluting that policy, but it was to strengthen the status of some communities in the SC population which have not been at the position of advantage vis-a-vis the other community within the SC population only, which are at more advantage than the disadvantaged one, right? So we'll see what are the facets of this article, what it wants to talk about, and how these three writers interpreted the judgment. First of all, it is said that the judgment is regarding the progressive jurisprudence, right, on social justice and upholding the caste sensitive affirmative action. Okay, so it is not to dilute the existing reservation system, but to strengthen the position of some castes who have not been able to take the advantage of reservation policy, right, as it is given here. So it is saying that the apex court has deepened the quest for justice by foregrounding the concerns of least advantaged and most stigmatized communities placed among the lowest rung of the caste hierarchy. Okay, so it is talking actually about the substantive justice, right? Substantive justice to the communities which are not even able to take the benefits of reservation, the benefits of affirmative actions by the government of India, right? Okay, so what are the misconceptions which spread among the community after this judgment? The first is that the legal constitutional objection that the court has usurped the domain of parliament, that is a violation of separation of power. But it is not like that, right? The court has not given a verdict that it is going to be there, the subcategorization is going to be there. The court has just said that it is an option under, or it is permissible under Article 341 of the Constitution. So ultimately the role of court is to interpret the Constitution. The role of Supreme Court here is to interpret the Constitution, and they have interpreted Article 341 in a way that there could be subclassification of SC community in general, right? And it actually is based on the previous judgment or E.V. Chinaiya judgment, right? So E.V. Chinaiya judgment was actually deeply flawed. That's why the court has now rectified that error and said that it is a possibility under Article 341 of the Constitution. Well, what was the second criticism? It was that the SC passing such major order without authentic empirical evidences. The writers say that there are evidences in the census itself, because in the census, not just the head count, but the occupation, family assets, educational attainments and everything of scheduled caste and tribes is taken. It is not taken for the rest of the population, which comprises of the general category or OBC category or others. It is taken for the SC and ST community, right? And on the basis of that only, right, on the basis of that only, this article is being written and this judgment is being given, right? So what we see is that the number of graduates or graduates or above in per 10,000 population rather than per 100 population, per 10,000 population within SC community in few states. So this data is being quoted here, right? So as you can see, there is from Andhra, Bihar, Maharashtra, Punjab and Tamil Nadu, right? These 5 states given, it is given here. So you can see one or other caste is at an advantage position than the other one, right? As you can see in Bihar, this caste, Dhobi caste, they have 257 graduates per 10,000 population. When you consider Musahar, they have only 5. So this much disparity is there among different caste only, right? This much disparity is there among the different subcaste of the scheduled caste only. And you can see in some cases it is way above national average for some groups, right? 564 is the national average, right, for all the people in India. So for some communities, way above that, right? So you can see these disparities there, which lies, it is on the basis of census, and that is on the basis of empirical evidence, right? And the thing is that there is nothing homogeneous about the educational disadvantage of Dalit communities, right? As I have taken the example from the chart only, so the same thing is being said here. Okay. And finally, the political objection which has taken place, that subclassification would create a political rift within the Dalit community. The writers are saying it is not that. See, the community itself, or the SC Jatis itself, is fragmented and fractured. The social and political expression among them is already fragmented and fractured, right? So according to writers, this will only create unities between these communities, right? By creating a broad and consociational arrangement between these communities, right? If the voices of relatively less disadvantaged community among the Dalit will be heard, right, will be acknowledged, and the agency of most disadvantaged SC community, like who have won and fought this hard battle, for this hard legal fight, right, it would be their voices would be heard, right? Okay. And the thing is that it is not something which the stance of anti-reservationist upper class elites is there, right? It is just talking about giving the advantage of reservation to the communities which are at the lowest rung in the caste hierarchy, even in the SC community, right? Okay, so now we'll move forward. What we have to see here is that we cannot rule out the possibility of subclassification being used as a ploy to reduce the number of eligible candidates for higher jobs, and using the not found suitable route to first keep the position vacant, right? So simple, I'll tell you in simple words what it is trying to say is that if such kind of policy is being taken into consideration, then what could happen is that if some candidate, okay, if see there are 20 seats, right, and the sub classification is there, right, 5 5 5 5, let's say, right, and we don't find any candidate in the last 5 of this sub classification, no one was eligible. So it is not going to happen that these 5 seats will go to the unreserved category, right? These 5 seats will remain as a backlog entry in this category only. It will not go to the unreserved category. This is what the Supreme Court has said, or Supreme Court has meant in their judgment. Okay, right? And another problem which here is that the multiple problem with the sudden application of creamy layer doctrine to SC and ST, right? One of the issue of creamy layer was not framed by the court, and litigants did not get fair chance to contest this point. Okay, so the thing is that what actually is creamy layer, this we have to understand here, right? So from a sociological perspective, in simple words, what I can tell you is that if there is a community and there is a benefit given to them, right, so over a period of time, those who reap the maximum benefit because of their social position within that community reaches to a level where they don't need that kind of benefit or that kind of affirmative action, then that group becomes the creamy layer. The same is being given here, is that what is actually a creamy layer. So intergenerational transfer of privileges, when there is intergenerational transfer of privileges is there, and assured social status, stable social network. So these kind of things are seen in the OBC creamy layer. That's why that creamy layer we can say, yeah, the creamy layer quota was given in the OBC, right? So if these three things exist, then only this concept of creamy layer can be applicable. So we can see that we can very easily see there is an intergenerational transfer of privileges. If someone from SC community has got into a power position like 30 or 40 years back, their children will be getting the benefit. But the assured social status and stable social network is not guaranteed, as it can be guaranteed to the other section, which is the OBC, right? This is my deduction from this, right? And three, the exclusion of creamy layer would reduce the pool of eligible candidates even further and open the way for transferring post to unreserved category, and this should not happen. So the writers are saying that what are the things which should be taken care of before framing such a policy, right? But the thing is that the exclusion of creamy layer was not an operational direction in this judgment, right? There is a real fear that observation by 4 judges in the 7-member bench could be used to challenge the sub-quota policy that may not use the creamy layer criterion. If this issue is not clarified in the judicial review, Parliament may need to step and remove this confusion, right? Okay. Then it has talked about the impact of this judgment on the ST community, right? So there is actually substantive data available for ST community also. Will not dwell into this because this article only focuses on SC community. So what you have to take from these article are these 3 or 4 points which I have said here, right? What are the problems which has been arising out of this judgment because of the misinterpretation of the judgment, right? And at the end, what they want to say, instead of protesting against the idea of sub-quota, the politics and policies of social justice should focus on correcting some flaws in the present judgment and move on to real long-term issues, right? The thing is that the idea behind reservation was that if reservation is given, the caste-based discrimination should end, right? So the focus of the policy should be on ending the caste-based discrimination, right? Caste-based discrimination should be ended. This should be ended, right? So the policy should focus on ending the caste-based discrimination rather than anything which dilutes the reservation itself. Okay, so this is what we have discussed here, right? Like the misconceived criticism which has been arising out of the judgment of the Supreme Court should be done away with, and the policy, if at all should be formed, there should be formed first of all taking in mind that we have to end the caste-based discrimination. Second of all, those who have not been able to take the benefits of the reservation, there should be some policy to give them the benefit, right? So many things can be done, right, in order to emancipate the condition of these communities who have not been able to take the benefit of the reservation. Okay, and the Supreme Court also wants this only. It was mere interpretation of Article 341 of the Constitution, and this is a possibility, and only Parliament has the right to do any kind of changes like that in the Constitution. Okay, so there is no other article today in the newspaper which is important. So I think with this I'll take your leave, and thank you so much. I'm sorry, right? Thank you once again for your very patient listening. Thank you.